Global Corporate and Specialty S.A.
Good morning.
Good morning, my lady. Good morning, my lords. I appear in this matter for the appellants and the defendants at trial, the war risks underwriters of the win-win. Also appearing with me are Mr. Walsh, King's Counsel, and Miss Aboagye. For the respondents, we have Mr. MacDonald-Eggers, King's Counsel, Miss Healy, and Miss Hepburn. And they appear for the respondents, the claimants at the trial. My lady, on logistical matters first.
Yes, I was going to ask you.
I'm told, my lady, that there is a problem with the live transcript in the sense that your ladyship and your lordships don't have login details. We're all happy to keep going.
We're all happy to keep going too.
In that case, let's keep going, my lady. In terms of bundles, you should have a core bundle and a supplementary bundle. And I hope you have those both in hard copy and in soft copy if you want it. There should then be, and I shudder slightly to say this, it's gone up, my lady.
Ooh.
There should be 5 bundles of authorities. There is a short further bundle.
I'm reassured that the extras have been put in the back of my 4th, so I do have 5.
That's great, my lady. There is plenty of space in the back of number 4, so that ought not to be a problem, at least in terms of space.
Thank you.
My lady, this is, as you know, an appeal from a judgment and order of Mrs. Justice Dias in the commercial court. It's my client's appeal. The intention, my learned friend and I have discussed this, is that in the usual way, I go first, he goes second, and I have a little time to reply to the extent that that's persistence.
And you've agreed on timetabling so that we fit in.
We've got 2 days, as I understand it, my lady, and I'm reasonably confident that we will be done within 2 days, subject, of course, to, if I can put it politely, the extent of interventions from the court. But yes, that's the intention. I envisage that we will be on our feet for most of the day, but I think that ought not to cause any difficulty.
Thank you.
My lady, my lords, Mrs. Justice Dias' decision concerned, as you will have seen, a claim by the respondents, respectively the owners of the vessel Win-Win, her commercial managers, her technical managers, and the mortgagee bank, for an indemnity in respect of the constructive total loss of the vessel following her detention in Indonesia under local law. And the claim was advanced under a war risks insurance policy. My clients, the appellants, are the underwriters. Your ladyship and your lordships will have seen that Lord Justice Phillips granted my clients leave to appeal in relation to 2 of the defences that were asserted at trial, and on both of which we lost. You will also have seen that those 2 defences are quite distinct and separate. The first is my client's case that there was a breach of the duty of fair presentation for the purposes of the Insurance Act 2015. And the second is that the loss fell within a policy exclusion. My lady, my lords, the way in which we intend to structure our submissions today on this side of the courtroom, if this is acceptable, is as follows. We intend to take the 2 defences in reverse order, so exclusion first and then fair presentation, lest any of the court, or indeed my learned friend, should read some significance into that. The reason is that the exclusion defence is relatively self-contained, whereas the fair presentation defence, as you will have seen, gives rise to a number of disparate points, some of which arise from the respondent's notice. I don't want the exclusion defence to get squeezed. If we take it first, I hope we can deal with it relatively quickly. We don't have to do that if you'd rather we did it the other way round.
That's fine.
I'm grateful. So the plan is that I will address you first on the exclusion, and that will be a good chunk of this morning. On the fair presentation defence, I will deal with knowledge. You will then hear from Mr. Walsh on inducement and on materiality. You will hear from Miss Aboagye on the respondent's notice arguments relating to the policy being composite, and then it will be back to me on affirmation. So that's the map. My lady, my lords, underwriters relied at trial on the exclusion from cover, which is marked E in the relevant wording, and which has therefore been referred to, not surprisingly, as exclusion E. The judge held that the claimant's claim did not fall within exclusion E, and underwriters submit that she was wrong so to hold. This appeal gives rise to a question of construction of exclusion E, It's not an appeal on the facts, and the reason it's not an appeal on the facts is that there is no dispute as to the basis on which the vessel was detained, and therefore as to what the relevant facts are. I propose to address you in relation to the exclusion under 7 headings. This is just to indicate where I'm going. First, I want to say something about the basis on which the vessel was detained in Indonesia, which, as I've indicated, is common ground. Secondly, I want to take you to the wording of the policy. Thirdly, I want to look with you at the wording of exclusion E itself, and in that context, I will give you a little bit of history. Fourth, I want to address you on the correct approach to the construction of exclusion E. Fifth, I want to say something about where we say the judge went wrong on her construction. Sixth, I'm going to urge on you what we in our skeleton have termed Underwriters' wider construction of exclusion E. And seventh and finally, in relation to the exclusion, I want to address you on Underwriters' alternative case, which is for a narrower construction, though still wider than the construction on which the judge alighted. So, my lady, my lords, turning then to my first subheading, which is the basis of the vessel's detention in Indonesia, undisputed, as I've said. The vessel was, as you will have seen, arrested in Indonesian territorial waters by the Indonesian Navy, and she was thereafter detained in Indonesia pursuant to Indonesian law. More particularly, she was arrested and detained by reason of 2 alleged violations of an Indonesian statute. That statute was Indonesia's Law Number 17 of 2008 on shipping, and the 2 provisions were Articles 1931 and 2191 of that law. The court will find a translation of those provisions in the supplementary bundle at tab 2, page 4. And this is a translation taken from the respondents' experts' report, the report of Professor Simon Butt. It isn't the one quoted in the judgment. The translation quoted in the judgment was the official certified translation. And as I fear is so often the way, the official certified translation makes a good deal less sense than the one produced by one of the experts. The reason I say that is that the translation of the words in the middle of the page, if you see the reference to Article 2191, every vessel that sails is obligated to possess a port clearance issued by the harbour master. The translation in the judgment renders that, I think, sailing consent letter, which is not an expression that is immediately familiar to the average maritime lawyer. But it was agreed at trial that port clearance is the right translation, at least that's what was meant, and indeed the learned judge does refer to port clearance elsewhere in the judgment. I ask you to note, my lady, my lords, that requirement that every vessel that sails is obligated to possess a port clearance issued by the harbour master. That's Article 219. And then Article 193 above it refers in subparagraph 1 to the provisions related to the traffic procedures. And one of those provisions is having a port clearance, and that was the vessel's problem, my lady, my lords. She didn't have one. The court will also see from this page and from the articles that follow on this piece of paper that both those provisions, if breached, give rise to criminal liability on the part of the master. And members of the court, it was agreed between the Indonesian law experts, and indeed the judge held, that the detention of the Win-Win did relate to the alleged violation of these provisions. And it was also agreed, and indeed the judge held, that the arrest and detention were at all times lawful as a matter of Indonesian law. This is not one of those cases, and there are examples of such cases in the law reports, where the local courts had no jurisdiction to act, or where they misapplied their own law. As the judge held at paragraph 133 of her judgment, and I'm quoting, under the prevailing Indonesian legislation, there was a legitimate and justified reason to arrest and detain the vessel. So the detention was one under an ordinary law, and the infraction which gave rise to the detention was the anchoring in Indonesian waters without a port clearance. And I'd also refer in that regard to paragraphs 46C and D of the judgment. We probably don't need to turn them up, but for your note, it's the core bundle tab 8, page 150, in which the judge referred to the marine experts' common ground that the vessel was illegally anchored insofar as she had not obtained permission or clearance to anchor in Indonesian territorial waters. Had she obtained that clearance, there is no reason to suppose there would have been any issue. So those are the facts that are relevant to this issue, and as I say, that is all common ground. So the question then is whether those facts fall within the exclusion properly construed. The judge held that they didn't, and we say that she was wrong to do so because her construction of the exclusion was wrong. My lady, my lords, my second subheading is the policy wording. I want to take you to the wording of the policy to see how exclusion E fits in. And while we're here, I will also seek to flag up provisions that are or may be relevant to the fair presentation arguments, so that we don't have to do that twice. The policy comprises a slip with attachments. There is also a cover note. You will find the slip in the core bundle at tab 16. In case you are using the soft copy bundles, though it rather looks as though you are not. Would it be helpful if I gave the references to soft copy bundles, or are we working off the hard copies?
Not for my part, thank you.
Not for me.
That makes my life easier, I'm grateful. So that's tab 16, and the court will see the slip. You can see the date, 29th of June 2018. The definition of the assured is NGM Energy S.A. and or Unimar Success S.A. as commercial managers, and or V-Ships as technical managers, and or owning companies as per attached schedule, and or associated and or affiliated and or subsidiary companies for their respective rights and interests. And the reason for that somewhat compendious wording is that this is a fleet policy. NGM Energy S.A. and Unimar Success S.A. are management companies within what has been termed the NGM Group. My understanding is that one manages bulkers and the other manages tankers. But we will see in a moment that there are specific assureds identified for the particular individual vessels, as you would expect. You will note, my lady, my lords, the reference to mortgagees, notices of assignment, loss payable clause as attached and or as may be agreed. We have an assignee, a mortgagee here. That's the fourth claimant, which was a mortgagee bank, and that was an assignee and a loss payee. The interest is identified as hull and machinery, etc., valued as per schedule attached, including independently war protection and indemnity and or crew war liabilities, etc. There's a reference, and we'll see this presently, to increased value and or disbursements in additional owner's interest. The vessels are the Lion M plus 14 as per fleet schedule attached. Sum insured is 100% of values amounts in the schedule. The conditions are identified as American Institute Hull, War Risks and Strikes clauses. Those are the clauses with which we are concerned, and I will show them to you presently. I don't think I need to show you anything else on this page. If we turn the page, we see that the insurance is governed by English law, and that's at the bottom of the page, and of course English jurisdiction. jurisdiction. We then turn on to page 337. You will see that the insurers are identified as Garex 100%. Garex is a French underwriting agency, my lady, my lords. The underwriting decisions were taken by representatives of that agency on behalf of its members. And the members of Garex, you'll see who they were for the purposes of this policy in a moment, vary year on year. So Garex take the decisions in Paris, but the underwriters themselves are in the London market and indeed elsewhere. Page 338 is the schedule of assureds, co-assureds and mortgagees. And it sets out, as you can see, the names of the individual vessels in the fleet. And our vessel is over the page at 339. There she is, the Win-Win. And you will see that the assured is identified as Delos Shipholding S.A. as owners. That is the first claimant and first respondent. There are two co-assureds, NGM S.A. as commercial managers. They are the second claimant and respondent. FML Ship Management as technical managers. They are the third claimant and third respondent. And then under the mortgagee column, we have the fourth claimant, fourth respondent, the National Bank of Greece. As I say, they are the mortgagees and they are the assignees. I think we can then jump on to page 349. Just to flag up the point I made earlier, these are the members of Garex for this underwriting year, and so for the purposes of this policy. And you can see from the names that those are the appellants, my named clients. Turning to the next page, page 350, you can see a schedule which sets out the insured values of the vessels. And number 12 is the Win-Win. We see that she's a bulk carrier. We see her year of build and her other statistics. And then we see her hull and machinery value with rates and premium. We see the IV amounts, and we see the owner's interest. And those three items added up from memory come to $37.5 million. So that's where the insured value figure comes from. Now, we saw just now that the conditions on which this insurance was written were the American Institute Hull War Risks and Strikes clauses of December 1977. And we find those in various places in the bundle. Some are more legible than others. The best place, I think, in which to find them is tab 20 of your bundle. And there we see on the top left what they are. And we read the words, this insurance, subject to the exclusion set forth herein, covers only those risks which would be covered by the attached policy, including collision liability, in the absence of the war, strikes and related exclusions clause contained therein, which are excluded thereby. Pausing there, that is a reference back to the American hull clauses. That's what the judge found, and it was common ground at all times. And you find those hull clauses in the previous tab, tab 19. You will see that they are also 1977, though a slightly earlier date. And so the structure is not dissimilar to, for those of us with long memories, the old London SG form with its free of capture and seizure warranty. There are risks that are excluded from the hull cover, as we'll see in a moment. And what the war cover does is to pick those up and apply them. On page 374, so in the hull clauses, the provision, I simply draw your attention to the provision at lines 4 and 5. That is relevant to an argument which arises under the respondent's notice, and you're going to hear from Ms. Aboaji about that later, so I simply draw attention to it. If we turn the page to page 375, at line 70, you see the perils clause. Please note the reference to arrests, restraints and detainments of all kings, princes and peoples. And then we can jump to the end of the perils provision, excepting, however, such of the foregoing perils as may be excluded by provisions elsewhere in the policy or by endorsement thereon. And that is our pointer to a provision on page 377, the last page in this tab. At the bottom of the page in bold, this is what is excluded here on. You see war, strikes and related exclusions. And it says that this policy does not cover any loss, damage or expense caused by, resulting from or incurred as a consequence of, and there is then a list. And if you cast an eye over them, you will see that the majority of the perils identified here are to do with war and hostilities, but not all of them, and we accept that. For present purposes, the peril with which we are concerned is A, that is to say, capture, seizure, arrest, restraint or detainment, or any attempt thereat. And we accept, my lady, my lords, that, at least for present purposes, that this language, capture, seizure, arrest, restraint or detainment, is apt to cover not only wartime or warlike detainments or those that have to do with hostilities, but also, subject to any exclusion, detainments other than in time of war, including detainments under the criminal law.
Sorry, but detainments, the last thing you said?
I'm sorry, my lady. It's apt to cover, subject to any exclusion,
Yep.
detainments other than in time of war,
Yes.
including detainments under criminal law.
Thank you.
And the reason I say that, my lady, is because there is Court of Appeal authority to that effect.
Okay.
And that is Miller and the Law Accident Insurance, which helpfully, and despite the fact that they are voluminous, is not in the bundles, but I don't intend to take you to it. And a case called the Eliza Glacial, and I do intend to take you to that presently. But for your note, it's in the authorities bundle at tab 19. I intend to come back to that case when I'm considering exclusion E more directly in a moment. So that is the exclusion which is then written back in to the war policy by the war clauses wording. And if we could please go back to the war wording at tab 20, page 378. I've dealt with the first part of the insuring clause, lines 2 and following. We've looked at the war strikes and related exclusions clause. That's what comes back in. There is then a further set of perils listed that are covered by the war policy. Again, mostly but not entirely warlike. And then, and of course this is what you are really concerned with on this part of the appeal, we have the exclusions. And the preamble is this insurance does not cover any loss, damage or expense caused by, resulting from or incurred as a consequence of. There is then a list, and the exclusion with which we are concerned is E, arrest, restraint or detainment under customs or quarantine regulations and similar arrests, restraints or detainments not arising from actual or impending hostilities. That's the shape of the policy. There are other provisions, but I don't think I need to take you to them. I'm going to turn then to my third heading, which is exclusion E, and where it comes from. My lady, my lords, this is a form of what one might term a regulations exclusion. Regulations meaning for these purposes laws. There are other forms of regulations exclusion that exist, and they are not all the same. In particular, the regulations exclusion in the English Institute clauses, to which the judge made reference in the judgment, and to which I will return presently, is different. I'm going to come back to why and how that matters, in the context of the judge's findings as to the proper construction of exclusion E. For now, can I draw your attention to this? The language at the end of this clause, and similar arrests, restraints or detainments not arising from actual or impending hostilities, I'll refer to it for shorthand as the and similar wording, although it's all important, is not in the English Institute clauses. So far as I'm aware, it's not in any other standard form wording. It appears to be special to the American Institute clauses and their predecessors, and I will tell you presently about what those predecessors are. You will have seen, my lady, my lords, that in the judgment, the learned judge said that despite the diligence of 7 counsel, as I think we then had, we've gone down a bit to 6 now, nobody had been able to unearth the history of exclusion E. We've carried out further researches in the course of preparation for this appeal, and we know a little more than we knew at trial, though still not a complete picture. I should say that I am particularly indebted to Mr. Nathan Twybill, who is sitting behind Miss Aboagye, and who is Mr. Walsh's pupil, who has unearthed much of what I am about to tell you. I'm very keen to give credit where it's due. So, the earliest form of the wording that we can find, and you may have seen this in our skeleton, appears in the supplement to the Code of Federal Regulations, the US Code of Federal Regulations, of course, and it was part of the standard marine and war risk policy of the US War Shipping Administration. It dates from 1944. A brief history lesson. The War Shipping Administration was established by the US Maritime Commission in 1940. It was authorised to provide marine insurance and reinsurance against war risks when commercial provision had dried up because of the war. There is some account of that, I'm not just saying it, in an article by a gentleman called Harry Hale in the Tulane Law Review. I don't propose to take you to it now, but it's in the Authorities Bundle, Volume 4, at tab 50, and that gives one a little history. Those arrangements did have an equivalent in this jurisdiction, and that equivalent was the War Risks Insurance Act 1939, which authorised the government of this country to provide insurance and reinsurance against war and king's enemy risks in time of war. Back to the US, the War Shipping Administration produced standard wordings on which government war risks insurance would be written. The Maritime Commission continued to produce those wordings, and they continued to form part of the supplement to the Federal Code after the War Shipping Administration was wound up. And the Federal Maritime Commission, which was its successor body, went on producing those wordings, we believe as late as 1976. After that time, they stopped, and I infer that what happened is that the American Institute clauses were promulgated and in effect took over. The supplement to the Code of Federal Regulations still exists, but it doesn't include insurance wordings. The earliest iteration of the wording that we can now locate, and this is earlier than what we knew about when we were in front of the learned judge, is in Authorities Bundle 4, if I could ask you to turn that up. Tab 51. Now, I should say, my lady, my lords, this document in its entirety is quite a horror of a thing. It is immensely long, and we really didn't want to burden you with the whole of it, so we have tried to be selective here. But you will see at the top it says War Shipping Administration, to which I referred just now. And there are all sorts of things in here. You can see from the chapter headings here, many of them have nothing to do with insurance at all. But the bit with which we are concerned, or the bit to which I want to take you, appears on page 1508, about 4 pages in. And you will find there, I hope, a heading that is War Risks Clauses. And that sets out perils. And then if you turn the page, you will see at the top of page 1509, following a list of very warlike perils, words which are by now familiar to you, but excluding arrest, restraint or detainment under customs or quarantine regulations, and similar arrests, restraints or detainments not arising from actual or impending hostilities or sanctions. In other words, that is exactly the same wording as the wording of the exclusion in the American Institute clauses with which you are concerned, save that the words or sanctions appear at the end. And just to be clear, these provisions, you can see that the next section on this page is headed War Risk Only Clauses. These provisions appear in several places in this document, but we've just given you one as an example. They're in the same form, wherever they appear. If I could then ask you, my lady, my lords, to turn up our skeleton on this appeal, which is in the core bundle at tab 4. I should say that our permission to appeal skeleton also appears in the bundle, but it is this skeleton with which you need to be concerned, because the permission skeleton sought permission to appeal in relation to a further ground where permission was not granted. So it's this skeleton. And the page to which I want to take you, please, is page 81 of the bundle. In fact, page 80. And you will see at paragraph 59.1, we have set out the provision to which I've just taken you and explained where we think the exclusion wording comes from. And if you then turn to page 81, in paragraphs 59.2 and 59.3, we give a little potted history of how the wording and syntax of the clause have changed or changed through the courses of the different versions of the supplement to the Federal Code. And the answer is not a lot. Vandalism and sabotage in, or sanctions out, and some playing around with the comma, but I don't suggest that the, happily, I don't suggest that the change of the comma is particularly significant. What you will also see, and we set this out in paragraph 60, is that at the same time, slightly different wording seems to have developed in relation to American cargo insurances. That's to say, wording that excludes seizure or destruction under quarantine or customs regulations with no and similar rubric on the end. And it was the knowledge of that particular state of affairs, and in particular the Blaine-Richards case, which you see referred to there and to which I'm going to take you shortly. It was that caused us to speculate that maybe the and similar rubric had been added onto the end at some point. Now, as far as we can see, it looks as though that wasn't the case, because the first record we have of something like the exclusion is what you've just seen in the supplement to the Federal Code, which looks as though it came as a package. Why the cargo clauses developed slightly differently, I can't say. It is what it is, but that seems to be the position. My Lord Justice Males is looking quizzical.
Well, I was just wondering if you really want to know. This this is fascinating, but how does a history which 6 counsel couldn't discover, but 1 pupil could, help us on the meaning of the words?
Well, my lord, what we say is this. We accept that it might be informative to a limited degree, but what we can say, and this is important, and you'll see this when we come to consider the judge's judgment, is that the wording that's now exclusion E predates the English exclusion, the exclusion in the English Institute clauses, which dates from later. That dates from 1959. So this is earlier. And secondly, I say this, the exclusion E wording appears to emerge at a time of war, when the focus of war risks insurance was understandably war. Can I turn then to my 4th subheading, which is the applicable principles of construction? And it's probably worth having the clause itself open again, whether that be in the judgment or in the core bundle at tab 20. There was at trial, and there is now, no issue between the parties as to the principles of construction that apply to determine what the clause means. This commercial contract, so the general rules of construction applicable to commercial contracts apply. I'm working on the basis, my lady, my lords, that I don't need to take you to Arnold and Britton and so on. I suspect that you are wearisomely familiar with that line of cases. So I say just this, the starting point is the words used. They must be looked at in the context of the policy as a whole. We do also say that you may, and I will come back to this, derive some assistance from the Aestem Generis and Noscitur a Sociis principles of construction, and I will come back to that. We also draw attention to the following principles, which are perhaps more peculiar to the construction of marine policies and marine war risks policies in particular. And they are twofold. First, the perils and the exclusions are to be construed together, and one does not have primacy over the other. And I take that from, I could take it from a number of places, but for present purposes, I take it from the Court of Appeals judgments in the B Atlantic. The B Atlantic, as you will, I am sure, know, is a celebrated case in this area, detentions, war risks insurance and exclusions. It went to the Supreme Court. I'm about to show you a passage in the Court of Appeal, but it wasn't doubted, overruled, or anything of that kind in the Supreme Court. So that is, I hope, Authorities Bundle 1. At tab 7. And the relevant passage is in the judgment of Lord Justice Christopher Clark at page 1314 of the Law Report pagination, page 259 of the bundle pagination. And could I ask you to read to yourselves, please, paragraph 34. My lady, my lords, to similar effect is the judgment in the Eliza Glacial, to which I'm going to take you in a moment. And then my second proposition is that where exclusions relate to regulations, quote unquote, they are to be given what has been termed a business-like construction. And I take that from 2 English authorities and 1 American authority. The American authority is the first in time, and I've already made reference to it. It's the Blaine-Richards case. Could I ask you please to go to Authorities Bundle 4. Tab 42. This is a cargo insurance case. It's about a cargo of beans. They had been fumigated with a pesticide that was approved for use in Europe, but not by the US Food and Drug Administration. The FDA issued a notice of detention in relation to the cargo as a result. And a claim was made by the owners of the goods under the cargo all risks insurance and the cargo war risks insurance. Of interest for our purposes is the war risks insurance, and the claim failed. And if we turn, please, to the next page, page 1352. At the very top of the page, in the passage marked, you see the wording of the exclusion from the war risks policy in that case. And I've already mentioned that cargo insurance wording seems to be a bit different, or seemed then to be different in the US from the hull insurance wording. That makes that good. I don't rely on the difference for these purposes. What I do rely on is what is said in this judgment about the meaning to be given to the words customs regulations. If we go, please, to the bottom of the page, you will see a passage marked. And you will see that it was argued that because FDA regulations were not technically customs regulations, not issued by the Customs Service, not issued pursuant to customs statutes, we believe, the US Court of Appeals held, that the phrase customs regulations in the war risks policy should be construed in a reasonable manner, which would give proper effect to the intentions and expectations of the parties. Therefore, detention due to regulations concerning imported food should be regarded as customs regulations. So a broad meaning given there to the expression customs regulations. The next authority, and I'm sorry to jump about among the bundles, is the Eliza Glacial, which I've promised a couple of times already that I'd take you to.
Sorry,
and that,
just before you do,
yes, my lord.
was customs regulations being used there in distinction to quarantine regulations, or just as a compendious term for both? Because one might think that's more in the territory of quarantine of goods than customs.
One might, but reliance appears to have been placed on the words customs regulations. There's nothing I can see either in the judgment or in the judgment below, which isn't in your bundles, but at which I have looked, to suggest that specific reliance was being placed on quarantine regulations. So it may be that it was being used as a compendious item, but on the other hand, the reference to customs regulations and the absence of authorization pursuant to the customs statute does rather suggest that it is that part of the provision on which underwriters were placing reliance. It's certainly been read that way by the editors of the textbooks. For example, in Arnold, it said that this is authority for the giving of a broad construction to the expression customs regulations. So, my lady and my lords, the Eliza Glacial is in the second of the authorities bundles at tab 19. And this is a case that was concerned with the institute clauses, English institute clauses exclusion. There is no authority on exclusion E. There is next to no authority on the American institute clauses at all. And therefore one is necessarily driven to some extent to finding parallels with the English authorities. So we're on tab 19 of volume 2, Handelsbanken and Dandridge, otherwise the Eliza Glacial. This case was concerned with the interpretation of the expression trading regulations, which has been in the English institute clauses since the 1983 revision. It doesn't appear in the American institute clauses. And the passage to which I wanted to take you is at page 560 of the internal pagination, page 48 of the law report. And if I could ask you please to look at the marked passage, you will see that the court refer to giving clauses 415 and 416. 416 is, you will see shortly, it is concerned with judicial process and any financial cause. So those exclusions are to be given, and 415, I should say, is the customs and trading regulations exclusion, but no and similar wording. So the court is enjoined to give those exclusions a business-like interpretation in the context in which they appear. There's then a reference back to Panamanian Oriental and Wright. That is better known as the ANITA, and is an authority which you will see popping up a lot in this area. It's the first of the big cases on war risk detentions and exclusions. So I take from this the business-like interpretation. It's then said that it's for the underwriters to bring themselves within the exceptions. That is right, and we accept that. And then you see again, as you saw in the B Atlantic, that in defining the insured risks, it's necessary to have regard to both the perils and the exclusions, since together they delimit the risk. So that's the point I was making earlier. One sees it again here, and the reliance is here on the wondrous. And then finally, in relation to the broad approach, as I say, to be taken to a regulations exclusion, can I take you to another B Atlantic judgment? There are 4 in the bundles. There are 2 first instance decisions. The way in which the B Atlantic worked was that there was a trial of preliminary issues before Mr. Justice Hamblin, and then there was a trial of all remaining issues, which was much longer and produced a much longer judgment from Mr. Justice Flo. This aspect is not one which went on appeal, I think, and certainly what Mr. Justice Hamblin said and what I want to show you was not overruled or challenged in the higher courts. So I'm in Authorities Bundle 1, tab 5 this time. And tab 5, and could I ask you to go please to page 137. And can I ask you please to look at paragraphs 22 and 23. So we see again the reference to the business-like interpretation. And then Mr. Justice Hamblin said, this means, secondly, that questions of construction need to be answered in the light of the fact that the clauses are to be used worldwide. So they must be given a wide meaning to the extent that they are intended to cover laws in force anywhere in the world. They cannot turn on niceties of local law. And there is then a reference to a decision of the Court of Appeal called the Cleovalos of Rhodes. The judge had quite a lot to say about the Cleovalos of Rhodes in her judgment, so I'm going to take you to it in a moment. So, pausing there, in terms of the lessons of construction to be learned from the cases to which I've just taken you, my submission is you take a broad approach, you don't look at niceties of local law, still less, I would submit, do you ask yourself whether the local law is a good law or a bad law. And I say that because there is a hint, well perhaps more than a hint, in Mrs. Justice Dias's judgment of disapproval in this case of the conduct of the Indonesian authorities. That is irrelevant. It might be relevant if any case were being run that the Indonesian authorities had acted without jurisdiction or improperly or something of that kind. There is no such case, and it's not what the judge found. She found that there was a proper basis under prevailing law for the detention of the vessel. My 5th subheading is the judge's findings and where we say she went wrong. She dealt, my lady, my lords, with exclusion E at paragraphs 107 to 133 of the judgment. And that is back in the core bundle at tab 8 The section on the exclusion begins on page 171. She sets out the law, and then her conclusions on construction begin at page 173, paragraph 107. And she construed the exclusion narrowly. She held, and I'm going to read from paragraph 119 on page 178. She held that an arrest, restraint, or detainment is similar for the purposes of exclusion E if the underlying purpose and objective of the arrest is materially the same as the underlying purpose and objective of an arrest under customs or quarantine regulations. So she is effectively construing similar as the same, and indeed that is how the respondents put it in their skeleton on this appeal at paragraph 73. They say materially, if not identically the same. And the heart of her reasoning, I submit, is in paragraphs 119 and 120 of the judgment. And after the sentence, which I have just quoted, she goes on to say that she substantially accepts my learned friend's submission that exclusion E, properly construed, arrives in a different way at the same result as clause 4.1.5 under the English Institute clauses. And she says that under the latter, the effect of the Kleovolos and the Anita is that customs regulations is to be construed broadly, which is right, beyond simply matters of customs duties to anything regulating exports and imports. And she says that in the absence of any similar wording, so that's the similar rider to our exclusion, this was the only way in which the clause could be construed to cover things to do with smuggling. By contrast, exclusion E has expressed similar wording, to which effect can be given by construing it to cover arrest for breach of any regulation which in substance equates to a customs regulation as construed under English law, whether the arrest itself is made under a customs regulation or some other law. And she then goes on to say that she thinks there is a significant difference in the wording between the English and American clauses. We agree that there is a significant difference, but not the one to which she points. So what seems to have driven the judge to the conclusion that she reached was an acceptance of a submission made by my learned friend below, that the American and English Institute clauses were or must have been intended to achieve the same thing. And with great respect to my learned friends and to the judge, that was an assertion. There is no support for it in either set of clauses, nor so far as we can see in any authority, nor any textbook, nor indeed anywhere. And there is certainly no reason in my submission to suppose, simply from looking at the wording of exclusion E, that it is intended to achieve the same thing as wording in different clauses. All the more so in circumstances where, as we now know, the American wording, in fact, predates the English wording. I'm going to take you now, if I may, to the English wording, given the prominence given to it by the judge in her judgment. And you will find that in the supplementary bundle at tab 1, supplementary appeal bundle. There was first a regulations exclusion in the 1959 version of the English clauses. This is the 1983 version, which is current, and as I've already indicated, it has been amended. It was amended slightly in 1983. The exclusions are at clause 4, and you see those at the bottom of the first page. If we then turn the page, you can see at a glance that these do not mirror precisely what is in the US clauses. So, for example, clause 4.1.6, to which you saw reference made in the Eliza Glacial, is for the operation of ordinary judicial process, a failure to provide security or to pay any fine or penalty or any financial cause. That has no equivalent in the American exclusions. The closest equivalent is 4.1.5. You see it doesn't have our or similar wording at the end. And you can see there the words or trading, which have been in this since 1983. Now, it's our case, and I'll of course come back to this, that the and similar wording in exclusion E must have some meaning. It would be a long phrase to be redundant. And indeed, the judge accepted that. But her way of making the wording not redundant was the comparison that we have just seen between the American and the English clauses. And her finding that, well, the English courts had to construe the expression customs regulations broadly in order to get smuggling caught. Whereas the similar wording, she says, does that legwork in the American clauses. A quick, but I hope relevant, diversion, if I may, on what the courts have done in terms of construing the word customs regulations specifically. The judge was absolutely right. It has been construed broadly, and I've already identified some authorities that are concerned with the regulations exclusion on a more general level. The key authority on this particular point, to which the judge made reference in paragraph 119, and I said I would come back to this, is the Cleovelos of Rhodes. And that you will find in Authorities Bundle 3, tab 35. Now this case, my lady, my lords, was a drug smuggling case. It was a case of a detainment arising from the vessel having been discovered with controlled drugs on board. That led to criminal charges against the officers and the crew, though they were later acquitted. And the vessel was detained in Greece under the Narcotics Act. And as one might expect, that was a criminal law, and it outlawed the import and the trafficking of controlled drugs altogether. Now, the appellant assureds were in that case seeking to persuade the court that the expression customs regulations in exclusion 415 of the English Institute clauses had a narrow meaning, and they wanted to persuade the court that it was concerned only, customs regulations were concerned only with duties levied on imports and exports, and not with criminal contraventions of the kind that was in play. And both the trial judge and the Court of Appeal rejected that submission. Could I ask you please to turn to page 1053 in the internal pagination. And the relevant part of the judgment of, it's Lord Justice Clark, as he then was. Not Lord Justice Christopher Clark, the previous Lord Clark. And it's paragraphs 37 and following of the judgment. You will see from paragraph 38 the reference to the Institute clauses being intended to govern the insurance of vessels on an international basis. the natural meaning is said to be that given to the expression customs regulations by the Court of Appeal in the ANITA. And you see here that Lord Justice Clark says that he can see no distinction between smuggling and infringement of customs regulations. There is then a reference to the Eliza Glacial. And if we turn the page, could I ask you to look down, please, to the end of paragraph 43. Now, reverting to what the judge in our case held, you can see from this that there is nothing in this case, nothing elsewhere in the judgment either, nor indeed in the earlier Court of Appeal decision in the ANITA, in which the court said, oh, well, of course, if there were some sort of catch-all wording of the kind that they have in America, under the American Institute clauses, we wouldn't need to construe the expression customs regulations in so wide a manner. Going back to the judge's reasoning, what she has held is that in the American exclusion, in our exclusion E, the words customs regulations have a narrow construction, that the focus is on the form of the regulation and not the substance concerned, that without the and similar rider, they wouldn't extend to smuggling, and therefore that is the purpose of the and similar rider. And that is the judgment at paragraph 119 to 120, core bundle tab 8, page 178.
Well, is that quite the whole of her reasoning? It's the difference also in the wording in the English Institute clauses of the introductory wording and the narrow wording of under customs regulations in the American wording. Exactly,
my lord. So she makes 2 points. The first is the existence of the rider and the fact that she starts from the premise that they're intended to do the same thing. And I've already tried to indicate that there's really no warrant for that. She then looks at the difference in wording and says, well, this is intended to meet the Cleobulos of Rhodes point. And your lordship is absolutely right. She then makes a point in relation to the under wording. So she compares the two wordings and she says there's a significant difference. Under is narrower than by reason of. And she says, well, that reinforces the correctness of my proposed construction. So
the English wording is arising from, is that right?
The English wording is, and it's, I'm taking it from Supplementary Bundle tab 1. Yeah. The English wording is arrest, restraint, detainment, confiscation or expropriation under quarantine regulations or by reason of infringement of any customs or trading regulations. So it's under for quarantine and by reason of infringement of for customs and trading.
Thank you.
Whereas exclusion E is under customs or quarantine regulations and similar arrest, restraints or detainments not arising from actual or impending hostilities. I'm sorry, my lord, it's sometimes hard to have the two, the distinction in mind unless you have them side by side.
It is, thank you.
And
Now-
I'm sorry, I wrote down, and I'm not sure whether I've got this right, therefore, that you said that the judge says that the clauses with which we're concerned, the US clauses, should be narrowly construed, and she took form over substance, as what I wrote down as your submission. But when you look at what she does say, for example, at 121, A, she says it's the substance and character of the regulations that the one's concerned with.
I don't think I did quite say, my lady, that
No,
she
exactly.
form
I
over
think
substance.
Precisely, I'm fear that I have
I
concertinaed what you said.
I don't think that is quite my submission. What she did, and this I submit, was where she her starting point was wrong. She accepted the submission that the American clause was intended to do the same thing as the English clause, and she then tried to rationalise that by saying, if that is right, what that and similar wording is doing is expanding the customs regulations part of the clause so that it encompasses smuggling. That entails reading the expression customs regulations and what it means differently under the English clause and the American clause.
Okay.
And I say that number one, there is no warrant for construing the American clause, which is earlier, by reference to a later set of English clauses. You don't compare and contrast and assume that they're intended to do exactly the same thing. You can see that they're different. You can see that there are different exclusions in the English clauses from the American clauses. But in any case, it would be pretty odd in my submission if the expression customs regulations by itself meant one thing in the English clauses and one thing in the American clauses.
So you say, do you, that you should effectively forget the English clauses, you should simply decide what our clause means, and the process which you should follow is to decide what customs regulations mean and decide what quarantine regulations means, and then consider to what extent those meanings are broadened by the or similar wording. Is that your approach?
Well, I say that you should construe the clause as a whole, my lord. You may get some assistance from other English and American cases as to what customs regulations means in exclusions of this kind. But what you shouldn't be doing is assuming that they're intended to reach exactly the same result, writing words in where they aren't there, or ignoring words that aren't there. And as to what we do say, my lord, yes, we say, construing the exclusion as a whole, you have to ask yourself what is meant by the words and similar, etc. And you will have seen that there are two ways in which we put our case on that, and I'm going to come to that in a moment. Can I deal then with the under?
Sorry, just to follow up my lord's point. Is it part of your submission that in the American clauses, the expression customs regulations is wider than the meaning which has been given to it by the English authorities on the Institute clauses?
That is not part of my submission. My submission is that it has the same meaning. And the reason I say that, my lord, is I said for two reasons. One is, given the international nature of these clauses, it would be strange if it meant something different. And the judge has found that they mean something different. And I do submit that that is odd. Number two, it's even odder if they mean something different than it otherwise might be, in the light of the Blaine-Richards case, to which I took your lordship earlier, the Beans case. Because that says that customs regulations is to be given a broad meaning. It's concerned there, as we've seen with FDA regulations, but it says you construe it reasonably, essentially you construe it broadly. So it would be strange, in my submission, if customs regulations had a broad meaning in our cargo clauses, the American cargo clauses, and a narrow meaning in the American hull clauses. That would be most odd.
So in neither jurisdiction does customs mean customs, in fact.
It
They both have
means...
to be, in both jurisdictions, they have to be construed more widely than what are strictly customs regulations.
What has been said, my lord, is that they concern matters in the realm of customs. That's the expression from the Anita. What it doesn't mean in either jurisdiction is laws or rules produced by the Customs Service. That is right. And that's clear. It's clear on both the English authorities and the one American authority that we have. Can I turn to the judge's under point? The judge suggested that the words under customs or quarantine regulations in the American clauses are narrower than the words by reason of infringement of customs regulations in the English clauses. And she suggested, as my Lord Justice Popplewell has pointed out, that reinforced the correctness of her proposed construction. And we say, my lady, my lords, there are a number of problems with that. The first I've already dealt with. That presupposes that you do construe the expression customs regulations narrowly in exclusion E, and there's no warrant for that in any authority which we have found. And indeed, it's at odds with the English and American authorities that we have seen. Secondly, as to the suggestion that the words by reason of the infringement of are somehow wider than the word under, we would respectfully suggest that that isn't so. Either there's no material difference, or if anything, on a natural reading of the words, under is wider because it doesn't require an actual infringement of anything by anyone. And in relation to that, can I take you please to one authority?
Doesn't that simply reflect the difference between customs and quarantine regulations? If you are subject to a quarantine regulation because you've picked up some disease somewhere, you haven't actually done anything wrong. You're just detained because you're unlucky.
It might, my lord, that might be so. Or, then again, it's certainly clear law that the owner need not have done anything wrong for the vessel to be detained. It could be a person or persons unknown. That was the position in the B Atlantic, and it was the position in the Cleovalos of Rhodes. And the owner was very, very unlucky in those cases, as we know. But I'm not sure I would even go as far down that road as your lordship. Firstly, because in the American clauses, the word under is used in relation to both. And secondly, because there's at least one authority that suggests it makes no difference. And that's the wondrous. And that we find in Authorities Bundle 2, if I may, tab 21. And this was a case on, amongst other things, the 1955 version, I beg your pardon, it's the 1983 version of exclusion 415 in the English clauses. And the relevant passage is on page 609 in the judgment of Lord Justice Lloyd. And helpfully, the passage to which I wanted to take you isn't the one that's marked. It's the one immediately following the one that's marked. Beginning, Mr. Hallgarton argues at the bottom of the page. And could I ask you to read through to the end of subparagraph 1 there. And so you can see that Lord Justice Lloyd was of the view that there was, to all intents and purposes, no material difference in that wording. And he said, if you ask why under is used once and by reason of the infringement of is used once, he says, have a care. These clauses weren't settled by an equity draftsman, and they're not perhaps as wonderful as they might be. Then the second authority of some relevance, it's a textbook, is Arnold's Law of Marine Insurance and Average. Now that is, there are bits in two places, but I think the best place to go is tab 54 of the authorities bundle, which is volume 4 or 5, depending on where that's gone. Now,
sorry, tab 50.
54, my lady.
Thank you very much.
I should say this just before anybody picks me up on this. Mr. Walsh and I are both editors of this work. We are not, however, editors of Chapter 24, or at least, strictly speaking, I have become the editor of Chapter 24 very recently, but I was not responsible for this version of it. I think this chapter, is the work of the late Mr. Gilman, and that is why I have now taken it on. But one always wants to address a submission that might be made in advance in relation to that. Now, the relevant page here, please, is page 1555.
I've just realised that my tab 54 contains only the first page, the table of contents. Do you, by any chance, have a spare copy?
Yes, my lord.
That's very kind.
Does your lordship have tabs 52 and 53 while we're there? Pick
Yes,
those up one page.
yes, I do. Thank you.
I'm grateful. It's coming.
Yes, I seem to have a complete copy of Mr. MacDonald-Eggers, but not of Arnold.
That's very dispiriting.
I'm very grateful, thank you.
Just perhaps to ground where we are, if we go first to page 1551. You will see that this is a section of the chapter that is concerned with the quarantine customs and trading regulations exclusion in the English Institute clauses. And if we jump ahead, please, to page 1555. And you can see the marked section at paragraph 2446. The view of the author of this chapter is that the exclusion in respect of quarantine regulations has not been judicially construed, but its interpretation should no doubt be approached in a similar way, save that the wording under quarantine regulations is broader. So the view in Arnold is that far from being narrower, as the learned judge held, in fact, under is a broader word. And the next sentence, which my own friend would like to see, is a loss by detention under quarantine regulations would, it seems, be excluded whether or not there was any actual potential infringement of those regulations. So, off the back of the wondrous and this passage, my lady, my lords, my submission is that, if anything, under is wider than by reason of an infringement of, see Arnold. It's certainly not narrower. It could be the same, see the wondrous. So my submission, my lady, my lords, is that the under point doesn't make the judge's reasoning any better. In fact, it makes things worse. And it follows that her suggestion that the and similar wording is intended to widen what would otherwise be a narrow construction of the words customs regulations doesn't work as a matter of language, and it doesn't work as a matter of logic, and it doesn't work as a matter of authority. And my submission is that that pulls the rug from under the judge's construction, because it then leaves you in a position where the critical wording at the end of exclusion E, the and similar wording, is given no effect. And that, we say, can't be right. So that brings me on, and you may think that I've taken a while to get there, but I'm there, as to the critical question for the court, which is how is exclusion E then properly to be construed in a way that does give sufficient effect to the wording at the end of the exclusion. And you will have seen from our skeleton that we advance two alternative constructions, and it is to those that I now turn. And I'm going to term those the wider construction and the narrower construction. And I'm now on my sixth subheading, which is our first proposed construction, the wider construction. And that proposed wider construction, my ladies and my lords, is that exclusion E, properly construed, excludes detainments under ordinary peacetime regulations, that is to say, laws. In other words, the similarity that is referenced at the end of the clause is found in the fact of there being regulations and the fact of there being an absence of actual or impending hostilities. And customs and quarantine regulations are given as examples of regulations of that type. But they are not a closed list. And that construction, we say, gives full effect to the words at the end of the clause. And if it's right, it means that detentions under a state's ordinary peacetime laws are within the exclusion. The judge and my learned friends take a number of objections to that. They say, first, if that's what the parties had meant, they'd have said it more clearly. Well, that's a point that is generally made on questions of construction, and in my submission it only ever gets one so far. I accept that the wording is not as clear as it might be, and no doubt we wouldn't be having these arguments if it were, but I do say it can't be an answer in itself. What I do say also is that such very, very limited authority as we've been able to find in relation to exclusion E or its predecessors does support a broad construction. I said earlier that there was no authority on this wording. There is certainly no English authority. And there is no American authority in which the meaning of the exclusion is part of the ratio. I don't pretend otherwise. What you do have are some dicta in a couple of older authorities. They're in the bundles, but the relevant parts are set out in our skeleton. And I want, I think, just to take you to our skeleton. If you want to look up any of the authorities, of course, we can do that. But this is probably the convenient way to do it. And that's full bundle, tab 4, page 84. And we have identified here a dictum from a case called Kalmar and Scott. For your note, that is Authorities Bundle, tab 43. Then there is another dictum from a decision of the US Armed Services Board of Contract Appeals, and that's Farrell Lines, and that's Authorities, tab 41. And as we've said in paragraph 73, judging from those dicta, in both cases, the court appeared to consider that what mattered, the key to the exclusion, was the lack of connection with actual or impending hostilities. And that, in my submission, does support a wide construction. and we've also referenced Mr. Hale's article. And certainly, my lady, my lords, none of those statements seems in any way frightened of a broad construction, whereby the key is the absence of actual impending hostilities. In further support of the, if they wanted to say it, they'd have said it more clearly point, my learned friends also point to the fact that there is wording available in the market that in clear terms excludes detentions under a state's ordinary law. That's right, I accept that. They point to the Hellenic Mutual War Risks Association wording. It exists. It's later in its origins than the wording with which we're concerned. But again, the fact that different wording does exist, different later wording, doesn't in my submission actually tell you anything about what this exclusion means. Secondly, my lady, my lords, the claimants say that the wide construction of the exclusion for which we contend would give rise to a radical change in the basis of cover. And the judge agreed with that in paragraph 114 of her judgment. She said that it would mean that the capture-seizure peril would be significantly cut down, and she found that that would be odd in circumstances where, as I've already noted and as we accept, those words have been found in principle, subject to exclusions, to be apt to cover peacetime detainments. Now, as to that, we make the following submissions. First, the principal purpose of war risks cover is to provide protection against war risks. We've seen that this wording was developed in time of war and in the context of the US government providing war risks insurance. We've seen that the exclusion in its original form appears at the end of a list of war perils. So my construction, in that context, our proposed construction is not so surprising, we say. But secondly, even under the English Institute clauses, which are in some respects more narrowly worded, though they now have the trading regulations provision, it's been recognised that the cover for peacetime detainments is much more limited than one might at first suppose because of the operation of the exclusions. And that's Arnold again. Authorities, tab, bundle 4, tab 54. And this time, please, page 1549. You can see above paragraph 24-22 the heading, capture, seizure, arrest, restraint and detainment, which is that peril, of course, with which we are concerned here. And if I could ask you then, please, to turn the page. You see the marked passage. And it's said here that the cover under this is the English clauses, of course, in respect of these two groups of perils, is made significantly narrower by the Home Government exclusion and the exclusions in respect of quarantine, customs and trading regulations. These exclusions between them go a long way towards restricting the scope of these heads of cover to Queen's enemy risks, achieving a significant result to that of the war clauses cargo, where the cover in respect of capture, etc., is qualified in a more direct manner. Cargo cover is, English cargo cover is limited to Queen's enemy risks. And then in the next paragraph, it said, the perils we're now discussing are sometimes referred to as political risks. Apart from capture, they're not perils which need to have anything to do with war. And as will appear, arrest, restraint and detainment are confined to political or executive acts. That's because, just pausing there, detainment under ordinary judicial process is not only excluded under the English Institute clauses, but there's authority to the effect that it is not a capture, seizure, etc. for the purposes of the insuring clause. But then the editors go on to say, but because of the exclusions and qualifying provisions, the range of political risk which is in fact undertaken by war risk underwriters is much narrower than might appear at first sight. So, if it be that our proposed wider construction does go a long way towards restricting the cover under this insured peril to King's enemy risks, or whatever the American equivalent of that might be, that shouldn't, in my submission, be regarded as untoward or as surprising. And so, my lady, my lords, for that reason, we do not accept that you derive any assistance from my learned friend's judgment, brilliant though it no doubt is, in Crowden and QBE, in which he held that he confirmed that the contra proferentem doctrine does not apply to an exclusion in an insurance policy. But he went on to say, if there is ambiguity and the effect of a wide proposed construction is to exclude all or most of the insurance cover that was intended to be provided, the court is entitled to opt for a narrower construction. We say that may be, but in the context of this insurance, it's not a conclusion which can assist him. In any event, the construction that we propose, the wider construction, does not exclude all or most of the insurance cover that was intended to be provided. There are plenty of detainments that will still be covered. Obviously, wartime detainments or detainments connected with war or hostilities, but also some peacetime detainments. Can I give 3 examples of those? That's to say, a loss that will not be excluded under our wider construction of the regulations. First is a case where the authorities in a particular country purport to detain a vessel for political reasons, but they don't rely on any law at all. Second is a case where the authorities say that they are relying on a law, but in fact they have no jurisdiction and the detention is wholly unlawful. And an example of that, I don't ask you to turn it up, but for your note, is a case called the Silver. It's a decision of Mr. Justice Burton, and it's to be found in volume 2 of the authorities bundle at tab 27. There was no arguable case under local Egyptian law for the vessel's arrest, and the local courts were held to have been acting in bad faith and for the purpose of extorting money. Or, as Mr. Justice Burton put it in paragraph 45 of his judgment, the Port Suez Court, through its judicial and quasi-judicial powers, was acting piratically, just the risk that is intended to be covered by this insurance. And the third case that won't be excluded on our wider construction is where there is some motive on the part of the authorities that even if there's theoretical jurisdiction under local law, the vessel cannot in truth said to be detained or causatively detained by reason of or under that local law. Rather, the proximate cause of the detention is unconnected and unjustified political interference of the authorities. That was a point which was run in the B Atlantic at trial, where it was said that the Venezuelan authorities had behaved so badly and the judges had been got at that you couldn't in truth say that the proximate cause of the detention was any infringement of customs regulations or by reason of infringement of customs regulations. Failed on the facts, but had it, one can envisage a case where it would succeed on the facts, and then the exclusion wouldn't bite. The final objection of the judge and the respondents to the wider construction is that the proposed construction would exclude what she termed politically motivated detentions. Well, as to that, first, it wouldn't, and those are the examples I've just given you. But secondly, and in any case, nowhere in this policy are politically motivated detentions identified as a peril or referred to as a touchstone which somehow ought to be covered. The exclusions in the policy don't focus on motive, and you will have politically motivated detentions, therefore, that are excluded. For example, where the authorities decide to have a crackdown on drug smuggling and detain vessels that last year might not have been detained, that is political in that sense, but that detention will be excluded under exclusion E. Detention by the vessel's home government is excluded. That's exclusion F. That could be politically motivated. Requisition is another exclusion. That could be politically motivated. So my submission is that referring to political motivation gets you no further. My lady, my lords, I am almost done on the exclusion. I have my last subheading, which is the narrower construction. I'm conscious that we do have a transcript, even though you can't see it. I don't know whether you think it's appropriate to break at all now or for me to crack on. I'm very happy to keep going.
I'd like you to crack on if you don't mind, thank you.
Very happy. So finally, my lady, my lords, the narrower construction of exclusion. E, this is my 7th and final heading. Could I ask you to turn up the wording of the exclusion again? Core bundle tab 20. Page 378. Now, I've already sought to suggest that similar in this context cannot mean materially the same as, which is what the judge found, because that would render the whole of the second part of the clause redundant. It doesn't assist in my submission to look, as my learned friends have, at the use of the word similar in quite different contractual contexts. That's something that's done in paragraph 73 of their skeleton. And in my submission, it simply doesn't help you to look at the word similar in the context of a demurrage clause, for example. In order to give the words at the end of the clause meaning, it's necessary in my submission to identify how the similar arrests, restraints and detainments not arising from actual or impending hostilities are similar to detainments under customs and quarantine regulations. And in order to answer that question, you do, I suggest, derive some assistance from the 2 canons of construction to which I referred earlier, namely the Eustem Generis and Noscitur as Sociis canons of construction, that is to say, of the same class, and it is known by its allies. I suspect you need little reminding as to what those principles are, but again, for your note, there's a useful summary in the first instance judgment in Financial Conduct Authority and Arch, the business interruption case, and that's bundle 3 of the authorities bundle, tab 37, at page 1106. And given that customs and quarantine regulations appear here in the same breath, in my submission you're entitled to ask, and indeed should ask, what is it that unites them, and what sort of detainments would be similar, that's to say, in the same class or genus. No case on what quarantine regulations means. My Lord Justice Popplewell asked me about Blaine Richards, and that seems to be, as I indicated, about customs, not quarantine. From the cases on customs regulations, I've already submitted that we know that the regulations can be concerned with duty, with the prohibition of imports, with smuggling. They can encompass detention under criminal law, see the Cleovalos of Rhodes, see the Anita. And there can be regulations concerned with the standards to be applied to imported foodstuffs, see Blaine Richards. And what we suggest, my lady, my lords, is that they're concerned with this. Laws concerned with state sovereignty or security, and in particular, which control the introduction of people or things into a state or its territorial waters. And we've termed that, for shorthand, clearances. Customs regulations say your vessel can't bring in your goods at all, or at least not without clearance. You can't enter or leave without clearance from the authorities. Quarantine regulations say you can't enter, you can't leave unless clearance has been given by the authorities. Now, my learned friends say, well, if that's right, the clause, if my proposed narrower construction is right, then the clause would extend to, for example, breaches of immigration regulations. So, for example, if a vessel is detained because of a stowaway on board. Well, it might. We don't shy away from that. Not least because, in my submission, that has far more the feel of a customs or a quarantine regulation than a war risk. And I appreciate that when one is getting into words like feel, it's all sounding a bit touchy-feely and non-contractual, but it's a word that's used in the Cleovalos of Rhodes. The word flavour appears in a different case where the AS Dam Generis construction is being considered. It's a footnote in our skeleton. And sometimes that is what you are looking at in the context of exclusions of this kind.
What about an exclusion, a regulation that excludes a vessel whose flag is that of a nationality with which the country is at war?
That would be outside. That would not be caught by the exclusion, my lord, because
On your construction?
On my construction, it would not be a similar arrest, restraint or detainment not arising from actual or impending hostilities. That's what the end of the clause says.
All right. Leave aside whether there are actual or impending hostilities. There is just a deep antipathy towards the principles of some country. I mean, exclusion of foreign vessels from particular nationalities, in simple terms. You'd say that's within the exclusion.
On this construction, I'm talking about clearances. And so there wouldn't be a provision for clearing that foreign flag vessel in or out.
Well, I think you've given your narrower construction a slightly wider meaning than that in your oral submissions, as really anything which the country did to preserve the state's security so as to control the introduction of the vessel, its cargo and its people. That's wider than clearances.
It is wider than clearances.
Are you sticking with clearances, or are you putting it as widely as you did orally?
The reason I'm hesitating, my lord, is this. In the Cleovalos of Rhodes, and I'm going to take you to the passage in a moment, Lord Justice Clarke cautioned against the need to come up with a compendious one-size-fits-all definition and say this is definitely what it means. There are always going to be cases around the edges where it's not completely clear. And he said, yes, you can do that, but you don't have to do that. You don't have to say this is definitely what it means. What you need to satisfy yourself is, well, is this detainment at least within the exclusion? So that's why I'm hesitating. It may be that one doesn't need an entirely compendious definition. Am I going for control within the country or its territorial waters, which is a bit wider than clearances? Yes, and the reason I say that is as much as anything the rider, which does include the reference to actual or impending hostilities. But in the alternative, then I pitch for clearances. And we say for these purposes, it doesn't matter. It doesn't matter, because this is a clearances case, like it or not.
You have to add, in order for it to work for you, or its territorial waters, if you simply think about control within the country, then that is quite a lot of what customs and quarantine regulations even widely interpreted, have to do with what comes into the land territory of the country, whether it's goods or people or diseases. And if that were the case, then a breach of immigration regulations would also come within the exclusion, because the country won't be very bothered if the stowaways or immigrants are on the vessel and stay on the vessel when it departs. What they want is to stop them landing.
In relation to immigration, my lord, I would accept that, but in relation to customs, a detainment under customs regulations could well relate to a discovery within territorial waters. Let's suppose that a nation's customs authorities were tipped off that a vessel was carrying drugs or some other illegal cargo. One knows that many jurisdictions do allow the arrests of vessels within territorial waters if crimes have been committed and bad things are being done. In my submission, this exclusion would certainly be apt to catch a detainment in a state's territorial waters under customs regulations, that's to say smuggling regulations. So although I accept that there is no reference in the exclusion to territorial waters, I don't submit that I'm writing anything in, because I submit that that's how it would be naturally understood.
Yes, well, I see that you could have a state, well, you could have, for example, Indonesia detaining a vessel because there were drugs on board, even if the drugs were not intended for Indonesia but Singapore.
Exactly, because a crime is a crime is a crime, and if they have criminal jurisdiction over the vessel when she's in their territorial waters, which you would expect them to do, then she could be detained in the circumstances to which my lord alludes. And we say it doesn't matter whether we go sovereignty or clearances, both of which we advanced at trial, but as part of the same narrower construction, because even if you go narrower and take clearances as the unifying factor, then we say that on the facts as found by the judge, the detention of the vessel has to be similar to a detention under clearance or quarantine regulations, because, and this is where I started earlier this morning, she was detained by reason of a failure to comply with the Indonesian law provisions that required her to be cleared for entry into territorial waters. Can I just take you to the passage in the Cleovalos of Rhodes to which I alluded just now? And that is Authorities Bundle 3, tab 35, page 1048.
Sorry,
I'm sorry, my lady, page 1048.
thank you.
And you will see a heading, The Approach to Construction. And could I ask you please to read the whole of paragraph 19? It runs over the page. And so, my lords, my lady, with that passage in mind, I have been urging on you two particular constructions. But it is open to you to ask the question in a slightly different way, and to ask yourselves instead this: in view of the wording at the end of exclusion E, and bearing in mind the unifying features between customs and quarantine regulations, is a detention under a law which requires a vessel to obtain port clearance sufficiently similar to a detention under one of those laws? And my answer to that would be yes, because all those laws are concerned with clearances, it is sufficiently similar and the exclusion applies. My lady, my lords, that was all I wanted to say about the exclusion ground of appeal. Happily, in terms of timing, I'm exactly where I intended to be. I infer that your ladyship would like me to crack straight on and not break, and again, I'm very happy to do that.
Yes, thank you.
So, unfair presentation. Before I launch into the issue of knowledge, which, as I've indicated, is for me to deal with, I summarise some key matters relevant to the unfair presentation defence, and these are, I hope, uncontroversial, either because they were found by the judge or because they are common ground. First, at the time that our policy was written, Mr. Evangelos Bayraktaris was a director, indeed the sole director, of Delos, as I shall call them. That's to say, the company which owned the win-win. The significance of that and the extent of his role is something to which I'll come, but that he was the sole director is not a matter of dispute. Secondly, in March 2018, the Greek prosecuting authorities brought a criminal prosecution against Mr. Bayraktaris, amongst others. The charges brought were very serious, and they concerned the smuggling of a large quantity of drugs on board a vessel. Thirdly, those charges were pending at the date of inception of the policy in June 2018. Fourth.
It may be entirely irrelevant, but are they still pending?
No, they're not, my lord. They're not still pending. At least we were recently told by the claimants that they were formally discontinued in January 2025, so January of this year. And I should also make clear, and this was to be my fourth point, it isn't, and it wasn't below, any part of Underwriters' case that Mr. Bayraktaris was guilty of those charges. It is the fact of the charges on which we place reliance. Fifth, Mr. Bayraktaris knew, as at the date of inception of the policy, that the charges had been brought against him and were pending. Sixth, no other representative of the claimants knew that. Seventh, the person responsible for placing the insurance for all the claimants was a Mr. Tsouris, and he was the insurance and claims manager of the NGM Energy Group. He didn't know about the charges, but then he didn't make any inquiries of Mr. Bayraktaris at all. And finally, in terms of, I hope, factual common ground, underwriters were not told about the charges, and they didn't know about them before the inception of the policy, and indeed till much, much later. The relevant legal framework is also, I hope, uncontroversial. We are concerned here with the position under the Insurance Act 2015 and whether there was a breach of the duty of fair presentation by reason of a failure to disclose the criminal charges. That duty, which was of course a common law duty, is now set out in section 3 of the Insurance Act. Could I ask you please to turn that up? That's Authorities Bundle 4, tab 45. Subsection 3 appears in the second page of the tab, at page 1378. You see that it's headed the duty of fair presentation. And I hope that the following are common ground. In order to establish an unfair presentation defence, underwriters need to show first that there was a failure to disclose a circumstance which the assured knew or ought to have known, and that is section 3, subsection 4A of the Act, and the judge found against my clients on that point. Section 3, subsection 4, subsection A also provides that the circumstances not disclosed have to be material, and the judge found in favour of underwriters on materiality. And thirdly, underwriters need to show that they were induced by the breach of the duty of fair presentation to write the policy on the terms that they did. And that we see from section 8 of the Act. Section 8 changes the remedies available to underwriters in the event of a breach of duty from the position which obtained at common law. At common law, as you will know, it was avoidance or bust, and section 8 gives something of a menu. On inducement, the judge said that she was against underwriters, although on analysis that's not so clear, and that is a matter with which Mr. Walsh is going to deal in due course. So for the unfair presentation case, my lady, my lords, we're going to deal with those three matters first, that's to say knowledge, materiality, inducement, before we turn to the two other matters relied on by the respondents in their respondents' notice. First, the impact of the composite nature of the policy, and secondly, there's an affirmation case run against me. As to knowledge, we put our case in two ways, as we did before the judge. First, we say that Mr. Bayraktaris's knowledge is to be attributed to Delos, such that Delos knew about the charges. Secondly, we say that there was a failure on the part of the claimants, and in particular Mr. Tsouris, who was responsible for the placement, to carry out a reasonable search, and that means that there was a breach of the duty of fair presentation because at least Delos and NGM, the second claimant, ought to have known about the charges. In other words, we have a section 4(3) case, and we have a section 4(6) case. And the judge rejected both those cases below, which meant that we didn't get first base, as it were, on the unfair presentation case. I'm going to deal with those two types of knowledge, or those two ways in which the case was put in turn. And for the purposes of this part of the submissions, my focus is very much on knowledge. And I ask you to assume for these purposes that the criminal charges were material to be disclosed, which is of course what the judge found. So I'm just looking at knowledge. So actual knowledge, you may have section 4 open, section 4 of the Act, and if not, could I ask you to turn it up? So that is page 1378 of tab 45 of the authorities. This section provides for what an insured knows or ought to know for the purposes of section 3(4)(a). And if one then turns the page, section 4(2) deals with an insured who is an individual, so that is not relevant to us. Instead, we are concerned with Section 4.3. An insured who is not an individual knows only what is known to one or more of the individuals who are A, part of the insured senior management, or B, responsible for the insured's insurance. We are also concerned with Section 4.8, which sets out various definitions, and it says that senior management means those individuals who play significant roles in the making of decisions about how the insured's activities are to be managed or organised. Now, although that is a definition, there are a number of terms within it which are not defined. So there is no definition of activities, there is no definition of managed, there is no definition of organised. And because these provisions are new, this Act is only fairly recently in force. So far as we are aware, there are no cases on what this means for the purposes of the Act. So this is, to that extent, new ground. I'm going to come back to the wording of the provisions presently, but as you will know, my lady, my lords, this is an Act which was the result of work carried out by the Law Commission, and it passed through Parliament under the Law Commission's Special Bills procedure. There are 3 sets of materials which the court might, or might not, but might find of assistance in determining what it means. The first of those is the Law Commission report which preceded the Act, and I want, if I may, to take you to part of that. You will find it in the same bundle as the Act itself. It's tab 47. It's a very, very long report, and of course it covers more than simply breach of duty of fair presentation, but we have sought to include in the authorities bundle only the sections that matter. And could I ask you please to go to page 1430. You will see there a heading where the insured is not an individual, and you will see a heading, the insured senior management. The clause numbers are slightly different because, in the way of things, there was movement between the Law Commission's report and the bill that was ultimately put before Parliament. But could I ask you please to read to yourselves paragraph 854 through to the end of 859 on the following page.
To what extent are we allowed to have regard to all of this as distinct from looking at the report for things like context and mischief?
I don't have the authorities in front of me, Manuel, but my understanding is that you are entitled to have regard to this in circumstances where it's very much what informs the Act in its final form, just as, for example, in the context of cases concerning the Carriage of Goods by Sea Act 1992, the court did feel able to have regard to the Law Commission report. The same, I think, is true, and I'm casting back in my own mind because it's a case I did, in relation to the meaning of the Contracts, Rights of Third Parties Act 1999, where I certainly recall taking the court in a case called Nishan and Cleves to the Law Commission report as an aid to construction. So I've been working on the basis that you can.
Is all this reflected, I'm sorry to interrupt, is this all reflected in any event in the explanatory notes to the Act itself?
It's reflected to a certain extent in the explanatory notes, my lady, and I was going to take you to those presently. But the explanatory notes are...
at the previous tab?
They are at the previous tab, and they are slightly shorter in form, and they don't go into as much of the detail as this does. Mr. Walsh points out correctly that there was no issue in relation to looking at the report at first instance. My lord, certainly Mrs. Justice Dias felt that she was able to do that.
You've got a series of worked examples in 859, which I don't think we find in the explanatory notes.
Exactly.
Unfortunately, the one worked example we don't have is anything resembling our case.
Wouldn't it be nice, my lord? We don't. There is no... It is fair to say there is nothing in the report, I think, which deals with the fact pattern that we have here, which is to say a single-purpose vehicle, a single-purpose shipping company. One can speculate as to why that is. It has occurred to me, but I am speculating, that it may be because that is certainly a creature known to the courts in this country, and certainly a creature known to all sorts of other jurisdictions, but you don't tend to have English single-purpose vehicle shipping companies, because that's not why you do it. However, this far I do go, my lord, although our precise fact pattern is not dealt with. What you might potentially find of some assistance, and indeed I suggest that you do, is item 3, which is a multinational or global corporation with subsidiaries. The Commission say, as we've discussed, we think that this type of policy would usually be construed as a number of separate composite contracts of insurance. That is correct. And they say, on this basis, each entity would be an insured with fair presentation obligations, and the knowledge of the board of the relevant insured would be attributed to it. Now, I don't suggest that's the same as our facts, of course I don't, but it is concerned with a corporate group with a number of different co-assureds, each of whom has potentially different directors. And what is there suggested is that in that situation, the knowledge of an insured's board will be attributed to it.
I wonder whether this is helping. So this seems to be focused particularly on what's meant by a significant role.
Yes.
Whereas, as I understand it, the issues with which the judge had to grapple were more what was meant by managed, what was meant by organised, and what was meant by activities.
Yes, the reason for my hesitation, my lord, is that those expressions feed into what is meant by senior management. And what the Law Commission is doing here is identifying who it considers would be senior management in different situations. So, in other words, although the learned judge was looking at section 4.8, which gives you a definition of senior management, it is for the purposes of what constitutes senior management in subsection 4.3. So they're not distinct inquiries. And the Law Commission draft bill, and we see that from paragraph 856 of the report on page 1430, and indeed 854. This is all part of the discussion is about who constitutes senior management. The definition is set out, and that's the definition that we do find in the Act as it was passed. But what the Law Commission is saying is, in effect, standing back. These are the sorts of people you'd expect to be within senior management In contrast,
We
and
don't,
this is-
do we? Do we get little 2 in the actual act?
it's paragraph 854, my lord, it's my fault.
Oh,
So 854 is the wording we get in the Act. 856 is the wording of Section 14C of the Manslaughter and Corporate Homicide Act.
Yep.
And the Law Commission say, in essence, they are inspired by that, but they have...
no, 854 is the same. So.
Yeah, 854 is the same. And one of the points that the Commission rejected was that it would be sufficient for there to be managing or organising of a substantial part of an assured's activities. And the reason for that, I believe, one sees at page 1432. And what they were doing was drawing a distinction between senior management and middle management. And they say we do want to catch senior management, whoever they might be, but we don't want to go too far down the tree. And they go on to say it may not matter, because if somebody has relevant knowledge, there's a good chance that they will be caught by the reasonable search requirement. Before we leave the report, and I will turn then to the notes, also possibly of some assistance is paragraph 891, and you find that on page 1438. And again, this gives some indication as to the thinking behind the provisions I suggest. And you will see that the Law Commission, again, as in the example we looked at just now, consider the position of a parent or holding company placing insurance on behalf of a number of subsidiary or group companies. And they say that the placing company should make reasonable inquiries of those companies, and we'll come on to that. But they then say that where the insurance cover is composite insurance, so that each company is an insured under a separate policy, the knowledge of the board of each company would be directly attributed to that company. The explanatory notes, my lady has referred to those, and they are indeed in the previous tab. The relevant paragraphs are paragraphs 54 and 55. And I draw your attention in particular to the last sentence, the second sentence of paragraph 54, which says that in a corporate context, this is likely to include members of the board of directors, but may extend beyond this, depending on the structure and management arrangements of the insured. Now, I accept entirely that this doesn't say this always includes members of the board of directors. But nonetheless, in my submission, the clear impression one gets from this is that what the Commission is doing is saying it could be more than the board. It's not just the board. There could be other people who have the relevant knowledge.
Well, it's saying the opposite as well. Likely to means won't necessarily. Likely to include won't necessarily mean all the members of the board.
I'm not sure I would accept, my lord, that it's saying the opposite. It says, I agree it doesn't say it always includes. To that extent, I suppose it might be said to admit of the possibility that a director might not be included, But the focus in my submission is very much on the extension. It's saying it's likely to be this lot, but it could be these other people who perhaps don't have formal roles in the company, but are the people who pull the strings. And then the one other piece of explanatory material, which doesn't perhaps take you a great deal further, but I draw your attention to it nonetheless, is the parliamentary debates. And that's pepper and heart, I do know that.
But before you get
yes.
there, paragraph 55 also is discussing senior management
Yes.
and individuals responsible.
Yes.
And it says those categories should be construed relatively narrowly, but are capable of being applied flexibly.
Yes.
So basically it all depends.
It may all depend. It may all depend. But I do submit, my lady, that the starting point is that one would expect directors to be caught. One may go wider. It's flexible. Why does it have to be applied flexibly? Your ladyship has just referred me to that first sentence, paragraph 55. But then the second sentence is talking about, actually, I withdraw that. The second sentence is talking about something slightly different.
Yes.
That was not a.
Anyway, I interrupted you. I'm sorry. You were taking us to pepper and heart material.
Just before we go,
Yes.
you say the starting point
Yes.
is that you expect directors to be caught.
Yes.
But isn't that because in the ordinary run of companies you expect the directors to be the people who are doing the directing of the activities of the company, and if in a particular case it turns out that they're not, then your starting point may be displaced.
I accept the first part of what your lordship has just put to me, which is to say that normally you would expect directors to be doing the directing. I don't accept necessarily the second part of it, namely that if they are not directing, they will be displaced. It depends on what one means by directing, and I will come on to submit shortly that the fact that a director might have fettered his discretion to act, or might have wide powers which somebody else is exercising, is no doubt a matter that you can take into account, but it doesn't alter the fact that he is a director who is...
But is it your submission then that somebody who is the sole director of the company will always be part of senior management?
Yes. And if I'm wrong about that, then I say that even if that is not right, on the facts of this case, he was. Not only is he a sole director, he's to all intents and purposes the only person in the company. And I'll come on to that.
And that's going to be because of the narrow but you would say nevertheless accurate way in which you define the activities of this particular company.
Yes.
I mean, you say it's basically just a paperwork company.
Yes. It's a single-purpose vehicle. Come on to that. It's a creature well known to the court. Very, very briefly on my pepper and heart point, it's easiest. We don't have the parliamentary debates in the bundle. We didn't burden you with those, but I set out the relevant extract in our skeleton at tab 4 of the core bundle, paragraph 18.2 on page 66. And that is just to show you where that wording in the explanatory notes came from. And again, in my submission, that supports the submission that I've just been making, which is that the concern that was driving this was, if you stick with the board, you're going too narrow.
Is it an unusual thing to have debates about what the explanatory note should say, as distinct from what the Act should say? I'm not sure I've come across that before.
No,
maybe
my lord, I see that. I can't shed a great deal of light on that, I'm afraid. Save possibly to say this. It may be that this is to do with the fact that the bill was going through the Law Commission's special procedure. And my understanding is that limits to a certain extent, I'm looking at my learned friend, but he's not helping me. My understanding is that it limits to a certain extent the degree to which you can amend a bill on its passage through both houses. It's a streamlined procedure.
Right, well, I just idle curiosity with it. It seems rather strange that
It tells me it's not right. Anyway, be that as it may, that was speculation, but I'm told it's more than speculation. There we are. That's what they said. And, my ladies and my lords, I accept that, forgive me, of course, I have to get myself within the wording of the Act, and we will go to the wording of the Act and to Mr. Barrack-Torres's precise position in a minute. But I do submit, as a starting point, that if it is really the case that a sole director of a corporate assured with no employees is not caught by this provision, so that if he knows a material matter, he doesn't have to disclose it, I do submit that would be surprising.
Why? If he's not concerned with the insurance at all?
Because he is effectively the only person. Well, 2 points, my lord. The first is that he is the only person in that company. And the second is that if he knows that, and I will come back to this, it is entirely possible, likely, that somebody in that position would have knowledge of a matter that was material to be disclosed. We know that that was the case here because, on the hypothesis on which I'm arguing, Mr. Barrack-Torres did. But there are other instances in which a director might well have knowledge of material matters, putting to one side moral hazard. I'm going to try to make that good in a moment, if I may.
But I thought you're on your point. It would be surprising if a company could have no senior management. And I believe myself, you'll need to explain why that's surprising, given that it's not only senior management who can give rise to disclosure obligations, but also those who are responsible for placing the insurance. So why would it be surprising in what may be unusual circumstances, but why would it be surprising for an assured not to have any senior management for the purposes of the Act?
Because where an assured is a corporate assured and is seeking to insure something, its interest, it is not a nothing. It is a company that does things, however limited. Somebody must do those things. That somebody is the person that manages them. It is not simply an empty shell.
Your assumption, or at least the assumption in Popplewell, is that if it's not the sole director, then it's nobody. But there are people who play significant roles in the making of decisions, and therefore fall within the definition of senior management, namely the two Mr. Boundariesses. They may not have any formal role within the company, but nothing in the section says they have to, and they are the people who, I would have thought, undoubtedly fit the definition.
I accept, my lord, that there can be senior management that is not a member of the company's board, or is not the company's sole director. But that doesn't mean that that director is not also senior management. And because
no,
that...
it doesn't mean that he isn't, but
No.
it does mean that there is no danger of a company being left without any senior management.
Save that the company on that hypothesis would have no senior management who was an officer or employee of that company. So on that hypothesis, the director is not senior management, the company's secretary is not senior management, he's the same person, the treasurer is not senior management, the president is not, these are all Mr. Bayraktaris in our company. What it would mean was that there was no senior management in the company and no one in the company placing the insurance, and that everything is external. And I do submit, I will seek to make that good, but I do submit that would be a surprising conclusion.
Well, the insurers are probably not very bothered by that, are they? Because they've never heard of Mr. Bayraktaris. They have heard of Mr. Moundress.
Well, the insurers are bothered if there is material information that is not disclosed. And the judge, my lord, found in my client's favour in relation to materiality. She accepted that the fact of the criminal charges was a piece of material information that wasn't disclosed. Now, if that's right, then the underwriters were very much entitled to be bothered. One can look at it this way. Suppose, leave to one side for the moment the facts of our case. Suppose that the sole director of the assured, of the owning company, is a convicted criminal. And I make absolutely clear, I'm not suggesting that that's Mr. Bayraktaris. Let's assume different facts. Suppose that the only director, employee, officer of the named assured is a convicted criminal. And let us suppose for these purposes that that gives rise to a serious risk that the vessel is going to be detained in a foreign port because of the nature of the crimes that he's committed. Or perhaps if he's wanted for crimes in the particular jurisdiction. I'm trying to make the facts as lurid as I can. In those circumstances, the underwriters would be most concerned that that was the case because of the risk that that would have of the vessel which they were insuring being detained. Detention being one of the risks that is the subject of cover under war risks insurance. So the fact that the insurers didn't necessarily know who the director of the ship-owning company was does not mean that they did not care. And that's where I cavil with your lordship. There's a distinction between what they don't know and what they don't care.
Well, I was thinking really that insurers might be concerned if they thought they were dealing with a company which had no senior management, because then there would be nobody, other than the person arranging the insurance, who had any duty to disclose anything to them of their actual knowledge. But they will know that they are dealing with somebody, with a company which does have senior management, even if the senior managers are not officers of the company.
That, my lord, I see, but it is no part of the statutory test that the insurer must know who the senior management is and have a concern as to that.
No.
The senior management is the senior management. I was going to go on next to Mr. Bayraktaris' exact role, but I think
this is probably a convenient moment, as long as it's convenient for you.
it is convenient for me, my lord.
And how are you doing?
I'm doing very well. No.
Well, that's taken as read. I think that's maybe. But in terms
of timing, I'm exactly on track.
Thank you very much. We'll start at 2 then. Thank you.